I want to start out with a little bit of a civics lesson to address as we begin to discuss the legislation that's coming up. That because you're here, you have a higher interest in things and much more educated in these areas. And so you know what the three branches of government and what their responsibilities are. You know, obviously you've got the executive branch who, administers the laws. You've got the judicial branch, and their role is strictly to interpret the laws, not to do what David has told us we've got now, to where they're basically making new laws by virtue of these words here and there. And then, of course, you've got the legislature that establishes the laws. They are the ones that are actually supposed to be able to write the laws. The judiciary can say this is unconstitutional, this is not the way the law can be, but they can't say, so therefore this is what the law is. The legislature's got to do that. So we're going to try, we've got a couple of pieces of legislation that we think will help turn the ship a little bit in terms of the whole separation of powers issues, to keep the judiciary from going to the extremes that they're doing. And the first one deals with the opportunity for the General Assembly to join lawsuits, to intervene into lawsuits that have been filed. And the whole purpose of this is that we've got situations where private litigants are increasingly calling on the courts to effectively set public policy because of these new novel interpretations of the Constitution, or they have expanded rights that were never intended by the General Assembly. And those are the very kinds of things that David was talking about earlier. And so to do this, we filed a bill, Senate Bill 2655, that allows the General Assembly to intervene. Now, what the mechanism of that is that this can be done in one of two ways. Either the two speakers, the Speaker of the House and Speaker of the Senate, acting jointly, can intervene on the issue, or a majority of the members of both the House and the Senate will be able to intervene in the suit. And simply put, it puts in a mechanism so that the General Assembly can have its day in court to do one of two things. One, to argue for the constitutionality of statutes as written, or against the intent of the law based on the words, giving new meaning to words. So they can argue for the constitutionality of a statute, or argue against some argument that would create new rights, such as David was talking about earlier. Or they could intervene for the purpose of opposing the creation of expanding the constitutional statutory rights when the Attorney General does not oppose those. So that gives them two different options there. And of course, this can be done, it's important for more than just the reasons of marriage. I mean, this could be a case involving abortion. It could be a case involving virtually anything to allow the General Assembly to curb the activities of the judicial activism that's going on and eroding our separation of powers and taking away from the legislature their constitutional right to legislate. And so, then again, it's to maintain the proper separation of powers and to ensure that the rule of law is maintained. If you've got situations like Dave was talking about, those continue to carry on, then it becomes where law means nothing. It can mean anything anybody says it is. And so that's the purpose behind that. The second legislation that's related to this is Senate Joint Resolution 88 by Senator Yeager. And this is a process by which he is seeking to amend the Constitution relative to the appointment of the Attorney General. Currently, the Attorney General is appointed by the Tennessee Supreme Court, 5 members. In this process, is largely, well, they've got they'll have a comment opportunity where people, the bar association or individuals who are interested can comment relative to individuals being considered as Attorney General, but the vote itself is basically private. There's no record of that. Now, what this resolution would do, as originally written, would allow the General Assembly to make that selection. And they would make that selection the same way they select the Secretary of State, the Comptroller, and the Treasurer, and that is by a majority of both the House and Senate voting for that same person. So the whole idea is to bring accountability and openness to the process. Now, the current process has been in place since 1870, and I'm sure it worked for at a time, but over the years, the Supreme Court has got to the point where it is no longer subject to the direct election by the people. As you know, since I think 1984, 82, they were started on these confirmation, basically yes or no type of thing. So there's really, they're not accountable to the people the way the General Assembly would be accountable to the people in this election. So basically, it's a closed process, and there's no public vote. Now, probably one of the negative that has resulted is that Senator Yeager is entertaining an amendment to the process to where it really doesn't have any real good effect, because it provides that the Supreme Court can nominate, they'll charge that the Supreme Court will nominate a person for the Attorney General, and in turn, the General Assembly will vote to confirm or reject that candidate. And if they reject it, then the Supreme Court has to give them another option. Now, I think the one difference is that under the amended suggestion, it provides that the Supreme Court would have to make their vote in the open, and so that everybody knows which justice voted for which person. So, but still, from our perspective, it doesn't really solve the problem. You still got the Supreme Court, who is not accountable to the people in the same way that the General Assembly is making these selections. So it will basically take until the 2022 governor's election for this thing to actually become implemented, if it passes this year. So it is a long process. The second category we're going to discuss is defending the schools that defend biological realities. And this is Senate Bill 2480, House Bill 2620, and it is sponsored by Senator Joey Hensley and Representative Andy Holt. And just to backtrack just a little bit, last year there was a bill for the Senate Education Committee that mandated that all public schools have a bathroom policy that is based on biological sex. Basically, it got shut down without even a vote. What we've tried to come up with this time is a common sense approach to this issue. What this bill would call for is that the state attorney general, if a public school system has a bathroom policy that is based on biological sex, then, and if they get sued by somebody like the ACLU, then the Attorney General will represent that school system. We originally had something in the legislation that would also provide that their judgment, if they happen to lose, that the judgment would be covered. However, as much as we thought we had taken out anything that a reasonable person could object to on this issue, we found out that was not the case. This has already been quite controversial. The first two sponsors, the first House and Senate sponsors that we had agreed to handle this bill, backed out because of pressure or reasons that they'll have to share with you about. But in any event, there's just a lot of pushback still, even on this, what I think is truly a common sense approach. If you've got a policy that says students go to the bathroom based on their biological sex, then if you get sued, we're going to represent you, because we don't want the ACLU or these other interest groups that are well funded bullying our school systems, because they know that school system will be inclined to want to settle the case just because they can't afford the cost of the litigation. So this is going to be this is intended to be just a little bit of an incentive. Now, another point that makes this thing a common sense approach, we also say that policy that is biologically based can include a provision that says you can make accommodations for those who choose not to use the bathroom based on their biological sex. You can have, a separate setup for those people. The key is being that all students are treated with respect and provide privacy. But still, we've already hit quite a bit of a roadblock, so we'll see how that plays out. And I think one thing that's come across is just the whole issue of whether the Attorney General can already do this. You may have read in the paper a couple weeks ago on this issue where supposedly there's this letter from the Attorney General that says that we, the Attorney General's office, already have the authority to represent these local school boards on this issue. Well, that is just not correct. That's just the nicest way I know how to say it. I've confirmed this with folks at the Attorney General's office, and the authority that they've got, what they said they would do would be to assist the school systems in such lawsuits, but that would not keep them from having to have someone to actually represent them. As a situation in Sumner County, similar in this situation, the Attorney General assisted Sumner County Board of Education on this lawsuit or complaint that was filed, but they had to hire their own lawyer and spent hundreds of thousands of dollars relative to that. So it's a relevant issue. We think it's important, and we hope that things turn around. And another important point. Again, this does not require anybody to have a policy on anything. The legislation doesn't say you have to have this. It just says that if you do, this is what the process will be. The next bill, real quickly, I've run quickly out of my time, is a Business Protection Act. Long story short, this bill would prohibit a state or local government taking discriminatory action against a business on the basis of that business's personnel policies, as long as those policies were consistent with state and federal law. So that is to say that if ABC Corporation was applying to the city of Murfreesboro for a contract, the city of Murfreesboro could not discriminate on them, against them, because perhaps their policy for family leave was not as expansive as they wanted it to be. So basically there's four areas: anywhere with employee benefits, wages, family leave, and anti-discrimination policies. If you meet those state standards, when you apply for a grant, you put in for a contract, you can't be discriminated because you don't have higher standards than what that state says. Because what we fear is that these cities will basically say, well, this is what you have to do to operate, but if you really want this contract, you also have to have a personnel policy that says this or that, which is beyond the state law. So this is trying to protect against that as well. There are two bills that would seek to limit or prevent Planned Parenthood from getting state funding, one of which deals with Title X funds, and these are the family planning funds, things such as contraception, breast and cervical examinations, things such as that. And basically, it provides that it would implement a standard that the Haslam administration has used, but it's not in policy, it's not in statute, that basically would prioritize those entities that receive that money. And basically the type of institutions like Planned Parenthood would be in that last category, that would basically be entitled to it only if there was no other entity in that county that could provide those fundings. Then lastly, there is a bill relative to Medicare and Medicaid funds. And it provides, if the bill is passed, it would direct the Commissioner of Finance and Administration to submit a waiver to the federal government, giving them the authority to deny payment to, or the use of entities that promote or encourage abortions, and whether that money would go either directly or indirectly to them. It would limit and prohibit those funds as well. Again, all that for the purpose of ensuring that entities like Planned Parenthood, whose main purpose is the promotion of abortion, not be the beneficiary of state funding.